One interesting aspect of the proposed changes to the HSR process, it'll be interesting to see if this is included in the final rules that come out in the coming weeks, is that the FTC and DOJ would require officer certification on the HSR form that the company has taken steps to preserve relevant materials. So one key question we're considering is, do these proposed changes create a premature obligation to preserve materials? Today's environment, you typically would not institute a document hold just because the transacting parties were filing an HSR pre-merger notification form with the FTC and the DOJ. Typically, the document hold would come later when the parties received a request to preserve documents from the agencies, either as part of the voluntary access letter or a second request. And just at the ABA Antitrust Spring meeting last week, DOJ's Deputy Director of Civil Enforcement, Suzanne Morris, emphasized that it's DOJ's position that the duty to preserve kicks in when a company can reasonably anticipate an agency investigation, even if this occurs before the division issues a preservation notice. I see we have a question.
We heard at that meeting that it's their position. Did anybody raise their hand and say, at what time does the DOJ issue their litigation anticipation hold? Is it before every HSR is filed, or is it at the time of 2R issuance, or not until there's a non-compliance? I know what's good for the use isn't always good for the enter, but the DOJ's own position about at which point they anticipate litigation is different than this regulatory proceeding has its own extra statutory obligation to start holding.
And today, does that mean that if you have two parties anticipating a transaction and they anticipate the likelihood of regulatory scrutiny from FTC and DOJ, that they would need to put a preservation hold in place as soon as they become aware of that substantive antitrust risk? Or is this something that doesn't need to be put in place until you actually file the HSR form and make this officer certification, assuming that stays in the final rules? And I think the importance of noting the officer certification, that's going to require somebody pretty senior at the company to have a thorough understanding of what steps have been taken to preserve documents and keep a thorough record of that moving forward in the event that there is a dispute. And I think it does create real challenges for our clients in considering the scope of the document hold that they put in place. At the time you file an HSR, there might be a broader swath of issues that are relevant to the transaction, but may not receive regulatory scrutiny. And in today's world, by the time we receive a request to preserve documents from the FTC or the DOJ, or receive a second request, you have a better handle on the scope of issues that the agencies are actually concerned about. What product lines are they looking at? And how to identify which custodians should be put under the document hold. So I think there's going to be difficulties with line drawing, implementing a hold at the HSR stage.